what copyright is all about. And it's really the protection that is granted to you, the creator of the work. Right? It's something that you own, and you need to protect it and ensure that you enforce the rights. Right? So copyright is a protection that you've been granted to the works that you've created. Now, jams in particular, our role is to manage on your behalf what are called neighboring rights. So in each recording that you hear being played, I like to say there are two broad groups of rights. There's a copyright in the, what we call the musical works, the lyrics and the rhythm component and melody, copyright in that. And then of course on the other hand, you have what are called neighboring rights. It's still copyright, but it's copyright in the sound recording, meaning the master. So, for instance, in Jamaica, Jacob on the one hand manages the copyright in the musical works, lyrics, composition, and of course jams is about the sound recording, that final work, the product itself that you hear. So that is our role. We deal with what is called the neighboring rights, right? And of course, what we do is it's classified as collective management. So simply put, all of you are here because, well, most of you are here because you're members of jams. And so you've given jams the rights to manage on your behalf the rights that you own. So rather than you having to pick up the phone and go call RJR, or try to talk to a nightclub operator, or an event promoter because your songs are being played at these places, we do the job for you, collectively as a body. So we negotiate on your behalf, collectively, right? That's collective management. That's what Jams does, that's what Jacob does, etc. Right? Next one. Now, who do we represent in a real sense? Jams represents the master rights owners. Right? Now, that is normally the label. Sometimes the executive producer. We use the term producer a lot, but I just want to be clear that it's not necessarily the studio producer. It's really and truly the person or the entity that generally finances the production, which is generally the label or the executive producer, right? So that person, by virtue of their role in bringing all the elements together and financing production, etc., they own the master rights. So it's really the master rights owners that Jams represents, which would be the labels, etc. Now, back one more. Walk with me for a second. Earlier, I said to you, Jacob represents the songwriters, composers, and publishers as well. Jams, at this moment in time, we represent the labels or the executive producers. However, remember now, the rights that Jams manages are called neighboring rights. Another category of rights owners fall under neighboring rights, and those are performers, the artists and musicians. Now, as it is in Jamaica, presently, performers don't have the right to earn from broadcasting and public performance rights. So amendments are currently being made to the Copyright Act so that performers likewise can benefit from similar rights, or the rights which producers have and authors have. Now, when that happens, Jams will be the body that represents producers, labels, and performers. Right? No, keep it going. Yes, keep it going, because this is going to be very, very significant. As it is in the UK, for instance, there's PPL that represents labels and performers. In Japan, it's RIAJ, labels and performers. In Germany, it's GBL. So wherever in the world you go, you generally have one body representing producers and performers, meaning neighboring rights as a whole. So when the law has been amended, Jams will likewise be representing performers as well, right? And that hopefully should be fairly soon. Now, in a practical sense, we represent a very large body of works. It's not just about local producers or labels. We also manage the rights of the majors. Sony, Universal, Warner, EMI, which is now part of Universal and has been split with Sony as well. So the majors control approximately 75% or thereabouts of the international catalog of music. And we have a direct mandate from all the majors. So when a Mariah Carey song is played, or Jay-Z, or whomever, whether it's in the dance hall or it's on the radio station, Jams is a body that is representing the labels that would have released those recordings. It doesn't matter the genre either. So it doesn't matter if it's EDM or alternative, it also falls under us as well. Right? And those are the majors. I'm going to run through this quickly. But I wanted to give you a very good perspective of what we do and scale of what we represent. 75% already covered internationally. Then you have the international independence. The international independence comes to us through bilateral and reciprocal agreements that we have with other collecting societies. So for instance, from the US, we have approximately, well over 15,000 labels from the US alone. From the UK, from PPL, we have over 10,000 labels. So it's huge, right? So that should give you the perspective. And of course, locally, we have several hundred producers, rights owners that are members of Jams, and it keeps growing. Now, quickly, these are the broad set of rights that the creators and owners have under the Copyright Act. So they have the exclusive right to make copies of the work, the exclusive right to distribute the work, and the right to broadcast, and the right to publicly perform. Those are 4 broad groups of rights. However, Jams, we do not manage all of those rights on your behalf. Right? Reproduction, making copies and distributing, that falls under what is generally called mechanical rights. Whereas public performance and broadcast, public performance and broadcasting, that is a performance right. So it's really the performance rights that we manage on your behalf. You still reserve the right in relation to distribution, reproduction, which you then would take now to the distributor when you do that deal with him. Right? So that's how it works. All right, next. Now, who did I give the right to collect my performance royalties? We're going to now get down into a situation which is facing Jams, a situation which is facing some of you, and maybe you don't even know it yet, but you're going to be knowing soon enough. Christopher Edmond spoke earlier about in a sense, the way in which technology, changing technology, and the change in the music business models, how those changes are now impacting on the kind of deals that are being done. So you now have digital distributors that are not just distributing your music anymore. It's not just about the downloads anymore. They're doing a number of other things. So when you sign that distribution deal, digital distribution deal, it is now also absorbing other rights from you, knowingly for some of you, unknowingly to most of you. So there are rights that you are granting to the distributor or a licensee, maybe it's a company that's licensing the works from you. And you think it's just a distribution deal that you're doing. You think it's just to sell records. You think it's just to distribute across the US or wherever else. It's much more than that in most cases these days. Right? And you now need to pay attention, go back to all of those contracts and take a look at it based on what, for instance, Mr. Greenberg will have explained to you. What do you look for? What are the clauses that you should now look at to see what rights you are giving up unwittingly? Clauses which rights which you do not intend to give up. Right? So you really need to now go back and pay attention to those because there are severe implications. I'm going to get into those in a minute. Now, the fact that you have become a member of Jams, it means that you have granted Jams the rights to manage your performance rights. Good? However, you have also done a distribution deal or a licensing deal, and you've inadvertently also giving that other party the right to take your performance rights. So we now have a situation where that party can also become a member of JAM because they have the right, they control the performance rights, so they can collect the performance royalties. So what we have discovered now is that, for instance, in Germany and France, we're not seeing a lot of royalties coming to us for our members. And why? Because already there are companies that are claiming the performance royalties. There are companies that are claiming them. And this is not just recently, this is going way back now. This is going way back. So when you're sitting there and wondering, how come I can't see any royalties from jams, from Germany or wherever? The fact is, in a lot of cases, some of the deeds that you've done, and it seems so simple, it has these implications where it affects the work that we do as well on your behalf. Right? So there are a number of things that will happen when we now identify, for instance, in Germany or wherever, that somebody else or another company is already claiming performance royalties, your performance royalties. And the US as well, I might add. But before I get into that, I'm going to just run through a little, well, don't move. So, sorry, you would have given us the right to deal with your performance royalty. You've also granted some of that to your digital distributor or your traditional distributor or a company that has licensed the recordings from you. But remember, once you are a member of a collecting society, it means that you would have granted that society the right to manage your performance rights. Okay, next slide. Now, the implications of granting more rights than intended to distributors and licensees. These are some of the implications. The first one, Jeff spoke about earlier. You get into a deal with a company that may not necessarily have the capabilities to fully exploit. And exploit in a good sense, no. They don't have the capabilities to fully do the deals and get your work, get the monies that you deserve from the rights, the body of rights that they have. So they have all of these rights, but they're not working all of the rights to bring monies in. So they're sitting on rights that you own, but you're only getting money probably in relation to just the download component, the distribution component, although they have other rights that have been absorbed into the deal. So that's bullet one. Rights granted but not being exploited. And the fact is, having granted them the right, prevents us from actively making claims on your behalf where performance rights are concerned, because somebody else has it. Which is why when you come to us to apply for membership, we ask you, what deals have you done? Because when we look at these contracts or agreements, we can then identify if you've already granted those rights to another party. Because we're trying to protect you, we're also trying to protect ourselves from lawsuits as well. All right? Rights being exploited, but no royalties for those other rights. So maybe they're actually exploiting the rights, but as Jeff said again, no royalties may be forthcoming to you for those other rights unless it was indicated in the royalty section of the agreement. So on the one hand, there's a grant of rights where they got all of these, but on the royalty side, on accounting side, in the same agreement, there was no reference to how you would not benefit from these other rights. So that's something you need to look out for in these agreements. You're giving away this, but what are you getting in return? So rights being exploited, but no royalties, you're not getting any royalties from those other rights. It restricts our CMOs' ability, CMO meaning collecting societies, management organizations. It restricts restricts your ability to join a collecting society. So once we see that, and if you only have 10 recordings, and you've already done a deal for those 10, and you've granted those rights, you would not be in a position to apply for membership in JAMS if those are the only recordings you have. Because at this moment in time, you don't control those rights. Right? And of course, you may end up joining a CMO, but it limits the earning potential through the CMOs. So you may have 100 songs, and you're doing well as a producer. And so you get a deal for 90 of those because they're the top recordings in the catalog, and you have only 10 unlicensed. So you may become a member of Jams with those 10, but guess what? Those 10 are not the most popular. They're probably quite inactive. And so what you're getting from us would probably be minimal, maybe minimal, in relation to what you could have been getting if we were managing the full body of the full catalog. The question is, for that 90 that is unlicensed, are you getting performance royalty? When you check your royalty statement, what do you see? Are you getting performance royalty on the statement from the licensee or the distributor? You need to check your statement properly. What are you actually getting paid for? What are they paying you for? Right? Now, what are really the causes of some of this scenario that we're facing? What are some of the factors causing it? One is very simple: poor record keeping. Right? And let's step on some toes, Poor record keeping. Right? A lot of you are guilty of this. Sometimes because you're just very busy. You just want to get the song made. You're in the studio, you're busy and things. So you don't actually you don't keep records, you don't document anything. And even when you do document, ask you for it a year later. Right? Poor record keeping. So poor record keeping is one, but also there may be other persons out there who are deliberately trying to claim rights. It happens, deliberately trying to claim rights which they don't own. That is one reason that causes double claims, because you have already done your registration, but here comes another party trying to claim, and for whatever reason they may be able to, whether here or elsewhere, they may be able to at least initially register, and make a claim. But ultimately, you discover that it's the same work that two parties are claiming on. And then what happens? A double claim situation arises, and both parties, of course, have to be notified, and then we try and have it resolved. When you try and have it resolved, if it's a bona fide case where the other party should be benefiting from it, then both of you can resolve it. If the other party really and truly is a frivolous claim, generally it's fairly easy enough to dismiss, unless Marissa was talking about copyright registration earlier. Some person may beat you to the punch, and you may find yourself in court trying to say, this is my work, but that other man actually have documentation, you have none. All right? So documentation, copyright registration, these are key things to do. As this is a business. Just like how a person who operates a retail store, or even the banks, Mr. Leachin and all, listen, music is about business, whether we like it or not. And we should treat it as a business. So you keep your records. You put things in place to protect your investment, right? Now, other things which are affecting this scenario is general lack of understanding of rights. It's very simple. You know you're a producer, you know you're an artist, you know you're a musician, but truth be told, you're not very familiar with the business side of it. So that lack of understanding of the business elements, it hampers your ability to make a return, a proper return. Because you end up making bad deals. Because you end up doing deals without professional guidance or legal advice. Right? And these are things that puts you sometimes in a position that you don't want to be in. Maybe sometimes the company offers you some good money up front, right? And you sign, but you sign without even getting proper guidance in terms of what am I getting this money for? What will be the implication a year from now? Right? It says, don't let the money be, or at least don't let the present money be because of your inability to make even maybe double or triple that maybe down the road. Think about what you have, what you own. What is this asset? Do you believe that it has value beyond what he's giving now as an advance and how much I'm going to get in royalty? Go proper deal, get proper advice. Invest in a lawyer. Even if you can't have a lawyer to say this is my lawyer, invest in some time. Pay for an hour or two. There are many lawyers in the house, well, not many, but your lawyers here, your lawyers elsewhere. Invest in legal advice. Right? It will pay off in the long run. And the last one, I mean, no offense to any lawyer in the house, but sometimes, well, you sometimes end up giving poor instructions to an attorney. Lawyers work off instructions. They work off instructions. So if you bring a contract to them and you yourself are not clear on what you want out of this deal, you may end up still with a bad deal. Because in terms of what is to go in, to go out, it's all about instructions sometimes, right? So you at least have to have at least a basic knowledge of what you want out of the deal. What you want to give up, what you don't want to give up, right? And even if you don't know the elements, then you sit down and you ask the questions. What is this saying? What am I giving up? What am I getting back? What do I actually own that they want? They may be simple or stupid questions to ask, but don't be afraid to ask them so that you can know how to advise them to structure your deal for you. Now, you don't want to end up in front of this guy, right? But the fact is, you may end up in front of this guy because when you do a deal with a company A, and then you do a similar deal with a company B or a collecting society, you have given both parties the right to do the same thing. Depending on how popular this song or this album or whatever it is becomes, and where money is involved and big money is involved, then it can end up with a lawsuit. It may end up in front of a judge because persons are going to enforce their rights. They're going to maintain their claim. They're not going to want to give up so easily when the big money is involved, right? So, if it is that you have done a deal A over here, don't rush off to do a deal B without ensuring that this deal B, don't ensure that it's not going to affect deal A negatively. Because you've already given that guy the right to do X. Don't try and give probably on an exclusive basis. If it's non-exclusive, then fine. But if you give Mr. A the exclusive right to do certain things, don't give Mr. B the exclusive right to do the same thing. Right? That is a recipe for litigation right here, when big money becomes involved. The other side of the coin is that they may decide to withhold. If they find out that you are collecting royalties from another company, where they rightfully should have been collecting this royalty and getting their share, they may start to withhold your royalty payments. That's also another possibility, right? And the implications for us as a CMO, this could affect your membership with us. Because if it is that it is only that all of the works that you've registered with us, along the way we now are able to identify that all of these works, the rights belong or are controlled by another party, then that could affect your status of your membership. Because what it means is that there are no rights, in a bona fide way, there are no rights that you have given to us to manage on your behalf. You purported to grant us rights, but in fact there were no rights because they're in fact controlled by another entity. That can affect the status of your membership with a collecting society, right? We may freeze the royalties as well, where there are double claims involved. The parties work it out. When it's resolved, we pay the rightful owner, right? So that's an option. Where it becomes necessary, we may initiate legal challenges on your behalf. So if it is that you had granted us the right before or in the first instance, and another company is claiming the rights, where they got their right to do that after the fact, we could challenge them to say that these rights were granted to us before. So this is the contract that exists and which is bona fide. But it could still have implications for you, because that company now could sue you. That company could turn on and sue you. Let's be careful, right? We could recoup against future earnings as well, if it is that we find out that we're paying to the wrong person. If we shouldn't have been paying you, and it should have been the other person, when it's resolved, we then recoup against future royalties which may have been going to you. The rightful owner gets it, right? So these are real implications that you may face along the way, some of you. Now, just in closing, there's a report which came out recently by the US Copyright Office, and it's a very important report because what it is actually talking about is a revamping of the music licensing market. So pretty much what we're talking about here, the whole business of licensing, they are looking at revamping, well, recommendations are being made to go to Congress to revamp the licensing market. Huge changes are being proposed. So for instance, this is a picture of what currently exists right now in the US. On my left, you have musical works. On my right, sound recordings. We're going to continue to keep them like that, right? Now, where musical works are concerned, there are certain rights involved here, as we had said earlier in the build-up, right? And those rights are, some of them are controlled and held and retained by the rights owners or the publishers, and they do direct deals with whomever. Some of them goes through ASCAP or BMI, because they become a member of these societies. And these societies then license radio, TV, etc., collect royalties and pay back to you. All right? So performance, can I get one of the, let me just borrow this mic. All right, so on this side, we have the mechanical rights, and we have the public performance rights. We're talking about the states now. Now, you know about Harry Fox, right? And music reports and support. Mechanical rights generally are routed through one of these companies or through the publisher itself, or directly through you, and then the whole download royalties from downloading and streaming kind of feeds its way back. Over here though, the public performance rights will have gone through ASCAP, BMI, CSAC, and royalties collected and feed the way back. What has happened over time is that it has become quite inefficient. So a company wants to license a piece of work, and they have to go now to, because there are so many rights owners in the song, they have to go to Harry Fox here, and maybe the publisher there, separate publisher to clear rights. So it has become fairly inefficient over time to clear rights, right? Because there are so many rights holders involved, so many agencies involved, so it becomes costly and inefficient. One of the proposals which the US Copyright Office is making, but before I move to that, and this is sound recording side, it's not so messy, except that I should mention that here, this red box. In this, let me see the producer in here who has songs played on Hot 97. Hot 97. Right, Hot 97, right. Hot 97, of course, is what we call a terrestrial radio station. AM, FM, terrestrial. Now, in the States, AM radio and FM radio, they do not pay to producers or artists. The labels, let me clear. They do not pay to labels nor artists. That's US law. Songwriters, composers get paid from all sources, but US law restricts labels an artist from earning from terrestrial radio. However, because of don't remember the name of the act now, the Digital Performance Act.
Digital Performance Right in Sound Recording.
Right. Yeah. Came about several years ago. 1995, good. Labels are now able to earn, but from digital performance, meaning satellite, and internet, and cable sources. Right? Next slide. This is the scenario they're now proposing, which is that, let's start with that same one. They're proposing to Congress that artists and labels now earn from terrestrial radio as well. This has been on the table forever. It's a long-running battle, but they're hoping to give it some new life. On this side, what they're hoping to do is to now simplify the licensing process. So rather than you now having to go to a publisher, Firefox, and several other agencies, they are proposing that companies like ASCAP and BMI, etc., become music rights organization, which is a more complete licensing body. So a company now wanting to license a work to use in a film or wherever could now go to one entity and cover mechanical and performance rights. They are proposing something like that to simplify the process. And there are many other recommendations, but I thought I'd mention that just in passing. I mentioned that just now. Right, I wanted to mention a few companies that you may be aware of, familiar with. As the market evolves, companies like InGrooves, keep going for me, companies like InGrooves, what we find out is that companies like InGrooves, they're also collecting performance royalties when you do a deal, or if you go through them. Right, so it's important to check a statement to find out. Now, some of these companies here that you're looking at, you will be familiar with most of the names. Nocturne, for instance, Red Bay, these are French companies. Back in the day, Jamaican labels would have done distribution deals with some of these companies. And rights were granted to them to collect performance royalty. So when we contact our partners in France, right? Sometimes we're seeing a claim coming through to us, or they're returning to us to say, these songs that you have submitted to us on behalf of your label, these companies are already claiming on these songs. So we now have to be going to some members and finding out what kind of deals they did, and then trying to go back to these societies with evidence, hopefully we get evidence, to show that the company did not have the right. So sometimes we have to forego the claim to say, well, they do have the right, let them go. Or here's evidence which says they don't. And other companies, IODA, VPAL, a lot of you are doing VPAL agreements. VPAL agreements, it includes the right, of course, to collect digital performance rights in the States and sometimes elsewhere. So do not look to jams. We're blunt right now. Don't look to jams for the royalties if you do a VPAL deal, right? For certain songs, we would not be collecting performance royalties from the States in relation to songs that you do via VPAL, because they would already be collecting those royalties. It's not just downloads, there are other rights. IODA likewise, I think maybe TuneCore. These are older companies that did deals back in the day, and some of those deals done back in the day, Ross Records, Mango, etc. Greensleeve. Some of these deals, you give up the rights to a lot of the works. And just like how I think somebody mentioned, Jeff mentioned the automatic renewal clause. The fact is, you may have done a deal for 5 years or 10 years, and you thought, well, the deal is done, the time is done, so I'm good. They're automatically renewed most times. Or even if they were not renewed, they're still collecting royalties. I'm going to wrap now. They're still collecting royalties because guess what? You have not been enforcing your rights, or enforcing the contracts, or looking at the contracts, And they too, probably sometimes deliberately or not, have not been paying attention to the contract to see that the term had ended and they should stop collecting royalties on those recordings. So it's a lot to chew on, but I want you to take action. There are some of you who we will have to contact in the near future in terms of situations that you may be in. And this is just a close. For the future, medium to long term, I think ultimately, as a collecting society, we too may have to then start going the route of becoming a music rights organization so that we're covering a wider body of rights likewise. Right? Already we have, the board has approved a proposal to start doing some limited form of licensing in terms of sample clearance and some other limited clearance as of next year. But so we will be coming to you, 2016, we will be coming to you for you to either grant us the right to do that, right? So either going to opt in or opt out of that. So you'll hear more about that though. So that is it for me. If you have questions, turning back over to the chairman, please feel free to direct them to me.
I honestly don't think it could be any clearer. That presentation was quite clear and eye-opening again. I want to urge us as music producers to be very mindful that we have entered into many such deals that may impact us in a negative way. And so we look into the future.
One of them, two of them, three of them, four of them, five of them, must bust project. Whoa, because the vibes is right.